Fighting a parking ticket in LA, or I fought the law and I won. I'm going to tell you the steps I took, a little description of each step, and an important lesson I learned. Fighting a parking ticket is really a three-step process. Step 1. You get the ticket and then punch an imaginary pillow in the air. Step 2. You make 2 written requests for a dismissal, both of which are laughed at and denied. Step 3. You get an appointment with a hearing officer and get yelled at for about 10 minutes, after which they mail you a notice that your ticket was dismissed. Note that you must first get denied twice before you can see a hearing officer. Step 3 will be the main focus, but it's important to get an idea about the first 2 steps so that you can understand the context of the final step. I walked into this without knowing anything, and I Forrest Gumped my way into a win. No one told me what I'd be going through or why. I didn't have a story to tell me what was going on. I'm going to share my story about how I won so that you can get an example of what a win looks like. Now let's talk about the first 2 steps so that you may understand how to approach the third. Step 1. You get the ticket. This is the most painful step. You either pay them or you fight for your money. I decided to fight for my money on principle alone. My goal was to get it dismissed or withdrawn. When I first went to the parking bureau, I asked about filing a motion to dismiss, but was told that I could not. It seems that, according to the bureaucrat with whom I spoke, there was no court involvement until I went to the appeal stage. So contesting a parking ticket in Los Angeles, according to the bureaucrat with whom I spoke, is something done entirely through the offices of the parking bureau, not the court system. Step 2. The double tap. Knowing that the courts were off limits, my next goal was to get a hearing. In order to request a hearing, you must first submit 2 different written requests, both of which will be reflexively denied. Here's where their psychological manipulation and cynicism becomes obvious. In order to get a hearing, they demand that you waste your time and theirs. They designed this so that you'll want to give up. Their goal is to take your money from you and then get you to leave them alone. Yes, they will make it as painful as possible. These are horrible people, and this is what they do. Anyway, after the second one was denied, I was able to request a hearing, which I did. Step 3. You talk to a hearing officer. Now, when they finally allow you to get a hearing, you have one of 2 choices. You can either have your hearing in writing, or you can have your hearing in person. I didn't want it to be on paper. If they're so easy to deny things on paper, I wanted to see it done in person. I wanted to see their face when they denied me. As for what I was going to do in the hearing itself, I gave myself a single goal. I wanted to know what facts they had to prove that their codes applied to me. It didn't matter what their answer was, I just wanted an answer to that question. I had never done anything like this at the time, so I kind of got the jitters. You're probably going to get the jitters too. Don't worry about it, just go through it. Once inside the hearing office, it wasn't that bad. I don't recall the entire 10-minute exchange that I had with the hearing officer, so I'm going to give you a stripped-down version. The first thing I asked her was, a determination was made that I violated one of your codes, correct? This was a setup question. Her reply was really long and involved a minor discussion about photographs of my car or whatever. She didn't technically answer my question, so I asked it again. This office has made a determination that I violated the codes of this organization, correct? To which she answered, yes. And to which I had the intermediary follow-up. And if you're going to accuse me of violating your codes, then your codes must first apply to me, yes? To which she answered, yes. Setup and follow-through. At which point I was able to ask my variation of the Excalibur question. What facts do you rely on to support the conclusion that your codes and laws apply to me? She dodged the question. My goal is only met if she answers the question. Instead of answering my question, she asked me if I was in a designated no parking zone. I told her that I wasn't debating the location of my car. I knew where my car was, and that was not my question. I just wanted to know the facts she relied on to form the conclusion that her codes and laws applied to me. Her reply was that the statutes gave her authority. Is this a responsive answer to the question? No, it's a standard dodge, which is easily met. She was just exchanging one word for another, so I did the same thing. I asked what facts she relied on to support the conclusion that her statutes apply to me. This upset her. She tried to flip the question on me and ask, "Are you saying that the law doesn't apply to you?" Now, if I was a newborn babe, I might have fallen for this, but I wasn't. I knew that if I answered her question, I was making a claim and then taking on a burden of proof. I would then have to prove that her laws don't apply to me. Now this is clever. Not only had she not answered my question, she also thought that she was going to trick me into taking on a burden of proof, which I didn't fall for. I sighed and said, "No, that is not what I am saying. My question is, what facts do you rely on to support the conclusion that your codes and laws apply to me?" Now at this point she started getting a little bit upset. Her voice started raising and she was using frantic hand gestures. On her fourth dodge, she decided to throw sand in my eyes to see if that would work. She told me that she had prima facie evidence of the location of my car. She used a Latin phrase, hoping that I'd be so confused that I would give up. I'll admit, at the time I didn't know what the word prima facie meant, and so I was stumped for a whole 8 seconds. I had to regroup because I knew she was trying to confuse me with words I didn't know. I decided that I wasn't going to let that stop me. I still had my goal of getting an answer to that question, and she had still failed to answer my question. I said that I did not know what prima facie meant, and she told me that she had photographs of my car. To which I said, "I am not contesting the location of my car in time-space. I just want to know the facts that you rely on to support the conclusion that your codes and laws apply to me." Now this is where she almost literally jumped out of her chair. Now the 5th time she dodged was really clever. She asked me if I was going to present any evidence to prove my innocence. This is Franz Kafka stuff. By indicating that I'm expected to provide evidence to prove my innocence, she's saying that I'm not presumed innocent. I missed that point at the time and I wish that I had noticed it, but I didn't. What I did remember was burden of proof. The burden of proof rests on the one making the claim, and she had yet to answer my big question. At the very beginning she claimed that her codes applied to me, and there's still that business of her meeting that burden of proof factually. So I simply replied, "No, I'm not presenting any evidence. My question was, what facts do you rely on to support the conclusion that your codes and laws apply to me?" Now at this point she decided that we were not friends and we were not hanging out anymore. She told me that she was concluding the hearing. To my dismay, she began her conclusory statements for the record, and she was going to conclude the meeting without even addressing my question. And so I spoke before she could finish her conclusory statements. This is where I Forrest Gumped my win. I somehow snapped into the mindset of dealing with an internet troll by using pure logic with a hint of innuendo. I asked the following: "Are you telling me that by not answering my question you have no facts proving that your codes and laws apply to me?" She balked. She did not even answer that question. She rushed through her conclusory statements, stopped the recording, and without saying a word to me walked to the door, opened the door, and then stared at me. It took me 5 seconds to finally realize she was literally showing me the door. When I walked out of the office, she told me that I was going to get a decision in 3 days. She went back into her office, closed the door, and that was it. I was left wondering what had even happened. 3 days later, I got a letter in the mail telling me that my parking ticket was dismissed, and the charges were going to be fully reversed. I could have my money back. Here's the big lesson that I took away. Identify a goal and form a plan to meet that goal. For me, in that hearing, the goal was to get an answer to my question. The general plan was to stay on point until I got a responsive answer. Every time she failed to answer the question, I just asked that question again. I never wavered because my goal was always the same. Had it gone to appeal, I would have asked the exact same question. And I also think that I would have won. Without giving me any facts, she's either willfully withholding evidence or she has none to present. In either case, it's a due process violation, and I win that appeal. And that's how I did it. Now get out there and contest that parking ticket.